Thank you, Pauline. Every year, at the beginning of the year, when the CCL committee meets to decide on a keynote speaker for our annual dinner, we move into a pretty animated and pretty contended series of sessions, and it sometimes takes us months to decide who is going to be our speaker from the wise and the wonderful and the radical options that we have before us. Well, not so in February 2015. There was no indecision. It was very clear who the appropriate speaker for the Council for Civil Liberties should be. The decision to invite Gillian Triggs was instantaneous and unanimous. And if you don't know Civil Liberties New South Wales, you don't know how rare that is. I could give a keynote address on why that was so obvious, and I hope somebody will write about it in the not too distant future in big terms. But to go to the core, there were two main factors. The Australian Human Rights Commission is a hugely important institution in Australia, and particularly given our ongoing absence of an Australian Bill of Rights. It's done tremendous work since its inception in 1986. Its establishment, even if it was meant perhaps to be a bit of a stop for not having our own Bill of Rights, was an extraordinarily good thing, as it turned out, for Australian democracy and for the rule of law, for growing understanding of and respect for international human rights covenants. So, from our point of view, an attack on the work, on the integrity and the independence of the Australian Human Rights Commission, albeit via an attack on its president, was in our view deeply, deeply disturbing. Like so many other organisations, and boy, Gillian, I bet it's a fantastic list of invitations. Like so many other organisations and individuals, we determined the institution and its president had to be defended in any which way we could. So that's the institution. And then there's the person who holds the president's role. Gillian, as we said in our blurb that has brought you all along, has had a stellar academic career, most recently, of course, as Dean of Law at Sydney University, as Challis Professor of International Law. She's combined her academic work with an international commercial legal practice and has had extensive work advising governments and doing things for governments, and maybe sometimes, Gillian, they listened. And, of course, with many international organisations. This year, I think I would say one suspects that that stellar reputation in the future might be a little overshadowed by people's respect for Gillian's response to the events of this year. I mean, these truly vile and irresponsible and reckless attacks on the institution and its president. This year, the President of the Human Rights Commission has manifested courage and dignity and apparent calm, and, well, one should say calm reason, really, in the face of quite astonishing, irrational and vile and reckless attacks, not only from politicians, but from parliamentary committee, members of parliamentary committees. Australians, I think, are truly fortunate that the Australian Human Rights Commission has been led by, if I may quote, an independent statutory officer of the calibre of Gillian. In summary, the New South Wales Council of Civil Liberties is right chuffed to have Professor Gillian Triggs, President of our Australian Human Rights Commission, as our keynote speaker tonight. Welcome, Gillian.
Thank you very much. Thank you. Thank you all down the back there. Thank you. Thank you. Thank you. Thank you very much. Thank you down the back there. Well, thank you very much indeed for that marvellous welcome, and it is very good to be with friends this evening. Can I also acknowledge the traditional owners of the land and say what a wonderful welcome that was that we had tonight. I thought it was terrific and very nice to know that those who were born in New South Wales are included in the idea of the welcome. But I was sitting there rather conscious of the fact that I'm a 10-pound Pommy migrant with dual nationality. Well, I will, of course, emphasise I've been so delighted and very honoured to be asked to speak to the New South Wales Council for Civil Liberties at this annual fundraising dinner. You are, I think, best placed to understand the phenomenon of the last few years that is of very deep concern to the Australian Human Rights Commission. That is the encroachment of executive discretion on fundamental rights and freedoms. Senator Cory Bernard calls this a power creep. I don't often quote Senator Bernard, but on this occasion, he's right. I've long admired the work of the Council since its beginnings in the 60s, and it's gratifying that there are many of you here tonight who are foundational members, but also gratifying that there are so many younger members here to take part and to support the work of the Commission, of the Council. And on checking your website, I noticed that many of your priorities match those of the Australian Human Rights Commission, including the lack of government transparency, custodial or administrative detention, and the death penalty in the Asian region. But you've also raised awareness of the Trans-Pacific Partnership and trade in services agreements that pose concerns for human rights and civil liberties. As these international trade agreements are technical, opaque, and secret until they're presented as a fait accompli to Parliament, we shall be vigilant in monitoring their implications for human rights. So I congratulate you on your work, and I encourage the donors to dig deep and to support this extraordinary work that you do and that has become so vital for modern Australian democracy. Well, I have been asked to speak to you a little bit tonight about the role of the Australian Human Rights Commission in what's undoubtedly been a year of living dangerously. I'm still in place and I've no intention of leaving the building. Well, life is likely to be and has long been perilous for human rights lawyers globally. I was in China a few days ago where 60 human rights lawyers were recently arrested on charges of disturbing social harmony. In Mauritius, the Human Rights Commissioners have been charged with treason and sedition. But it's also been a perilous year in Australia, where our federal executive government has embarked upon an unprecedented erosion of fundamental liberties and diminution of the checks and balances that preserve our democracy, all in a year in which, ironically, we also celebrate the 800th anniversary of the Magna Carta. This evening, I'd like to discuss the overreach, in my view, of executive discretion in the dozens of new federal laws introduced by recent governments and passed by compliant and complicit parliaments, with the effect of diminishing the powers of our judiciary and threatening core democratic principles of the separation of powers and independence of our courts. Over the last 14 years or so, the major political parties have agreed with each other to pass laws that threaten some of our most fundamental rights that we've inherited from our common law tradition. Indeed, respective governments have been so remarkably successful in persuading parliaments to pass laws that are contrary, even explicitly contrary, to common law rights and to the international human rights regime to which Australia is a party, that it's become deeply concerning, particularly since the conflation in the public mind of the events of 2001, the Tampa crisis on the 26th of August, the children overboard misstatements by ministers on the 6th of October, and of course on the 9th of November, the terrorist attacks on the United States. Australian parliaments have passed scores of laws that infringe our common law freedoms of speech and association and movement, the right to a fair trial, and the prohibition on arbitrary detention. These new laws undermine our healthy and robust democracy, especially when they grant discretionary powers to executive governments in the absence of meaningful scrutiny by our courts. Well, tonight I would like to focus on the proposed laws to strip citizenship from Australians with dual nationality, and on the extensive use of administrative discretion, detention in particular. But I'd like to give you just a list almost of some recent examples of risks that I think lie to our democratic system. And some we might begin with include restrictions on the right to freedom of speech. And you'll know that the current government came into power with a view that it should abolish or amend Section 18C of the Race Discrimination Act on the ground that it restricts freedom of speech. We've seen a 180-degree turn to see some of the most profound restrictions on that freedom of speech, knowing, of course, that the general Australian public rose up to defend Section 18C and did so very successfully. But one of those examples is the Australian Border Force Act, passed this year at the Commonwealth level, that provides that medical officers, teachers and other professionals employed by the Department of Immigration and Border Protection are subject to 2-year prison sentences for speaking out about conditions in immigration detention, if to do so will affect the operations of the department. And I'd have to say that one of the great successes of the Forgotten Children report that we produced last year, not tabled until this year, was that we brought child psychiatrists, members of the medical profession and paediatricians with us. And when they said every child in these detention centres is sick, that carried huge credibility for the purposes of our report. And so I am particularly and very personally disturbed at this legislation, which provides or creates a chilling effect on the willingness to speak out, to the detriment of the public's right to know what is happening in these detention camps. We have new crimes of advocating terrorism that are vague and ill-defined. We have data retention laws that will now be applicable to 24 million Australians that are so extreme as to be a sledgehammer to crack a nut. We have rules that any disclosure of information in respect of special intelligence operations will attract a mandatory 5 or 10-year penalty. But ASIO officers carrying out these operations have total immunity from civil and criminal prosecutions if they breach or go further than their mandates. Governments can apply for journalist information warrants to compel the surrender of a journalist's metadata to identify their sources. But curiously, that warrant is not necessary in respect of everybody else. Lawyers, medical officers, and others working professionally in various fields that might in one way or another come close to a special operation. Then we have the problem of the independence of the judiciary and a significant diminution in the discretion of the courts to consider individual circumstances. Mandatory sentencing laws at the federal level were at once quite unusual, even rare, but they are now becoming accepted practice. We have reversals of the evidential burden of proof in criminal trials, restrictions on freedom of association laws, particularly, of course, the notorious bikie laws. I have a son who's a bikie and has some highly undesirable friends, and I often imagine I'm going to have to drag him out of jail somewhere for associating with them. But this is something that touches every Australian family. Australians cannot enter declared areas, such as the Mosul district of Iraq and Al Raqqa province of Syria. And a criminal prosecution for violation of these declared areas will attract a mandatory 10-year prison sentence with the evidential burden on the accused to show a legitimate reason for being there. We have good governance principles of transparency and good proper process being ignored. We have senior appointments and captain's picks made by Cabinet without the usual public advertisements or competitive selections. We have secrecy and lack of transparency with regard to on-water operational matters to stop asylum seekers seeking our protection. And we have non-compellable ministerial discretions of ministers, particularly under the Migration Act. We also have a failure to give effect to many of the human rights treaties to which we're a party. But if that wasn't bad enough, we now have new laws introduced late last year, some of them I might add 2 weeks before Christmas, under the Maritime Powers Act, which ignores or takes out all references to the Refugee Convention, which has been an underpinning part of Australian law since the Second War, since it was, of course, agreed in 1951 after the Second World War. A refugee is now to be defined according to the minister's view of what amounts to a refugee, and officers who might be carrying out laws to remove people picked up on the high seas will be immune from prosecution, and they are explicitly immune from any obligation to comply with Australia's treaty obligations or to comply with our domestic administrative law natural justice provisions. And that's in the new provisions of the Maritime Act. But many of these laws have come into existence without any public debate or very little understanding that they've been happening at all. They happen in Canberra, they are introduced late at night or 2 weeks before Christmas. There's very little understanding of the import of this legislation, and I've given you just a very few of them. But what it does is lead me to make a very obvious point to you. These laws have been passed by Parliament, and I believe it's time for us to ask the question, what are the proper limits on the power of Parliament? What are the safeguards of democratic liberties if Parliament itself is complicit in expanding executive power to the detriment of the judiciary and ultimately of all Australians? What are the options for democracy when both major parties in government and opposition agree on laws that violate our fundamental principles under the common law? So one question of course I ask myself, I've been a public international lawyer since I did my law degree in the 1960s, a rather long time ago, but I've had a great belief in the rule of law, not only in domestic law, but in Australian law, and it's been my privilege to have my career watching that international legal environment develop. And I hope you'll excuse the reference right back to the Doc Evatt that we all know and love, an irascible and difficult man, I'm sure, but a man with an extraordinary vision for Australia. And he went to New York to work with Eleanor Roosevelt on the 1948 Universal Declaration on Human Rights. He had a great vision, not only for global human rights, but for the place that Australia would have in that human rights development. But what has actually happened by the second decade of the 21st century is that I suggest Australia has become isolationist and exceptional in its approach to the protection of human rights. And how has that happened? We've been a good international citizen, I think, for the most part. But we have some major difficulties. We've been engaged in negotiating and ratifying the international treaties to which we're party, but we very typically do not introduce those treaties into Australian domestic law. And you will all know, of course, that constitutionally those treaties can have no domestic impact until they're given domestic legislation by Parliament. So the critical agreements, such as the International Covenant on Civil and Political Rights and the Convention on the Rights of the Child, are not applicable in our courts. Our Constitution protects freedom of religion, the right to compensation for the acquisition of property, the right to vote, and our High Court has implied a right of political communication. But very little more exists in terms of constitutional provisions. The Australian Constitution was designed as a practical solution to the need to establish a federal structure that respected the rights of the states. It was not inspirational in the way that, for example, the United States Constitution is and was intended to be. But also, unlike every other country in the common law country in the world, and most, I should say, civil law countries, Australia has no charter and no Bill of Rights. Compounding our isolation from international human rights jurisprudence, the Asia-Pacific has no regional human rights treaty and no regional court to develop human rights law or to build a regional consensus. It might be thought that we could rely on our courts to protect common law rights and liberties. Laws passed by Parliament are not to be construed as abrogating fundamental common law rights in the absence of clear words to the contrary. Our courts have employed the principle of legality to adopt a restrictive interpretation of legislation to protect common law freedoms. And it's presumed, for example, that Parliament intends to act in conformity with international law. But in practice, this has proved to be almost totally ineffective. The presumption of legality applies only if there's ambiguity in the words of the legislation. The rationale being, of course, that Parliament is the lawmaker and the task of the courts is to interpret and implement those laws. But our laws today are drafted with such precision or are so constantly amended and re-amended that ambiguities are extremely difficult for the courts to find. The Malaysia solution case, for example, illustrates this problem. The High Court found that under Section 98A of the Migration Act, the minister could not send asylum seekers to Malaysia as that nation had not ratified the Refugee Convention, and they'd be at risk of refoulement. The government, of course, immediately returned to Parliament and deleted the offending clause, leaving open the possibility of further offshore processing arrangements with Asian nations where so many states are not party to relevant human rights treaties. So time and again, the High Court has limited executive discretion by reference to principles of statutory interpretation and the principle of legality, but time and again, the government has been successful in asking Parliament to tighten up that legislation to permit what was hitherto illegal. I believe that the Malaysia solution case, but many, many others, illustrates how respective parliaments over the last few years have failed to exercise their traditional self-restraint in protecting democratic rights. Historically, Parliament has been a bulwark against sovereign or executive power. Sadly, Professor George Williams estimates that there are currently 350 Australian laws that infringe our fundamental freedoms, and he suggests that prioritising governmental power has become a routine part of the legislative process, stimulating little community or media responses. But underpinning my powers about executive overreach is the doctrine of separation of powers that is absolutely vital for our democratic system. It's a concept that lawyers learn about at law school, but that's hardly ever part of public commentary in Australia and very infrequently taught to our young students. We've got three arms of government: executive power that rests in the Queen and is exercised by the Governor-General, Parliament with the power to pass legislation, and the courts are required to interpret and determine whether the law has been complied with. The rationale for the separation of the three arms of government is that sovereigns or executive governments, from King John of Magna Carta to Charles I of England, who of course lost his head, to the present day, will almost always seek to augment their autonomy. This is a given. We have to expect it. It's the function of Parliament and our judges to provide the checks and balances against the inevitability of executive overreach. But I believe it's been the institutional failure of Parliament over the last decade that poses one of the greatest risks to our individual liberties today. With these rather general comments about Australia's exceptionalism, the very odd position that we have a bulk of law in the international environment, much of which is not implemented or given effect in the domestic environment, you'll understand the rather curious position in which I find myself as President of the Human Rights Commission, because my mandate is the international treaties. My mandate is not the domestic law, with some exceptions in relation to discrimination issues that we handle at the Human Rights Commission. So I may argue to a minister that to act in a particular way breaches the International Covenant on Civil and Political Rights or the Convention on the Rights of the Child, and the minister says, well, that's all very academically interesting, but it's not relevant to Australia because Parliament has not passed laws to give effect to those treaties. I must say I think Australia is the only country in the world where to say someone's academic is a put-down. In other parts of the world, if you've written a book, people think you're terrific, but not here, which is a great pity. But I mustn't be a victim. That's a great problem I've learned. One must never succumb to these sorts of comments. But it is an issue in Australia because we are facing a battle in which we are drifting away from the language of almost all the rest of the world, and certainly the parts of the world we want to be compared with. Even our cousins in New Zealand have a Human Rights Act, and the sky has not fallen in. But if you're going to Geneva, if you're talking to Europe, North America, Canada, and many parts of Europe, of Asia, we find that we're really not talking the same language anymore because in Australia we simply don't view our laws through the prism of the international standards to which at least comparable nations expect to be compared. But before I look at my particular examples, I'd just like to make one sort of comment, and one is that the legal test of validity is whether legislation is necessary and proportionate to meet the legitimate aim. This is a standard legal test of validity, both at international law and domestic law. And it might be said that some of the examples I've given you tonight might be seen as relatively trivial, or let us wait and see whether the DPP actually makes the prosecutes, or let's see what the courts actually do with it before somebody in my position draws attention to it as being a problem. Now, maybe in some areas that would be justified. Of course we need new reformed anti-counter-terrorism laws. Of course we have to deal with problems of security checks and health checks for asylum seekers and migrants. But the difficulty is that when you start to look at this legislation coming down the track at us year after year, the sum of the parts becomes much more than that. We've created a serious, I think, intrusion into the fundamental freedoms that I know are so important to this, to the membership of the New South Wales Council for Civil Liberties. So we see, I think, not just individual pieces of legislation, but a systemic and disproportionate intrusion on our individual liberties. But there are two that I'd like to focus on, and one is the counter-terrorism phenomenon and the loss of citizenship laws. It's quite clear that our counter-terrorism laws needed to be modernised, and we recognise, of course, that terrorism is highly individual and typically not state-based. But I'd suggest that the strength of the rule of law is much more truly tested when security is threatened than in times of peace. When Australia is threatened by terrorism, the need to protect our traditional liberties assumes an even greater urgency. Many counter-terrorism laws go well beyond what might be deemed to be proportionate, creating a chilling effect on many of our rights. The Australian Citizenship Allegiance to Australia Bill, which is now before Parliament, has just been introduced to ensure that Australian citizens accused of fighting for or in the service of a declared terrorist organisation, or of acting inconsistently with their allegiance to Australia, a term never used before in Australian legislation, will be stripped of their citizenship automatically, including that of their children, if they're dual nationals. The wording of the bill is ill-defined, but it does explicitly include a ground for automatic loss of citizenship being the damaging of Commonwealth property. I think most of us haven't the slightest idea what constitutes Commonwealth property, and technically a graffiti could amount to something which cuts the tie of allegiance with the state. I suggest that the loss of citizenship for dual nationals, including those who have spent most, if not all, of their lives in Australia, strikes at the heart of Australia's successful migrant and multicultural nation and threatens social cohesion. Under current law, the Minister has the power to revoke citizenship if a conviction for specified offences has been made. But it's now proposed that revocation arises by operation of law rather than the initially proposed subjective ministerial discretion. No decision is actually required by the Minister under this bill. although it's implicit that an official somewhere in the system must work out or determine that a breach of allegiance has occurred. But the minister does have a non-compellable discretion to exempt the citizen from the automaticity of the loss of citizen if the minister considers it appropriate to do so. The minister cannot be required to think about whether he'll exercise that discretion, and if he makes a mistake, he's not bound by the rules of natural justice. Well, Magna Carta has got something to say about this. It provides that no man is to be outlawed or exiled except by the law of the land. And this ancient principle raises the question whether it's consistent with the rule of law for Parliament to pass legislation to withdraw citizenship automatically, subject to the discretion of a minister. I suggest that it's not only contrary to the Magna Carta or the spirit of the law, but it's also contrary to the International Covenant on Civil and Political Rights that protects the right to enter and remain in one's own country, and to the principle of separation of powers for Parliament to revoke citizenship automatically and then to grant discretion to the executive to provide an exemption from the Act. The effect of the bill is to allow the executive not only to pass laws through Parliament, but to determine when those laws will apply. Well, the government argues that the right to fair trial is not threatened by the bill because there's a right of judicial review of any decision made by the minister not to exempt a person from automatic loss. That's true. A court can review whether the power under the Citizenship Act has been exercised according to law. But all the law requires is that the minister can exercise that discretion as he considers appropriate. In short, the courts have nothing to review and the exercise will be futile. In this way, the courts are, for practical purposes, excluded from the process. There is merely a theoretical power to review the unreviewable. I suggest that this bill diminishes the judicial power to make determinations and will, if passed, be a significant overreach of executive discretion facilitated by a compliant Parliament. The debate over citizenship has become one between the subjective satisfaction of a minister or some official within the department versus an evidence-based determination by a judge according to established rules of evidence and law. Well, the second example that I wanted to discuss of overreach of executive discretion lies in arbitrary and indefinite detention. And again, we can come back to the enduring words of the Magna Carta. No free man is to be imprisoned except by the lawful judgment of his equals or by the law of the land. But over recent years, respective parliaments have granted governments the power to detain indefinitely various classes of persons, obviously, of course, refugees and asylum seekers, but also those who have infectious diseases, those who are mentally ill and unfit to plead to criminal charges, or are subject to mandatory admission to drug and alcohol rehabilitation facilities. Few of those detained under such laws have meaningful access to legal advice or regular independent judicial or administrative review. The Australian Human Rights Commission has become increasingly concerned by the growing instances of detention in prisons of those with cognitive disabilities for significant periods of time in the absence of regular review by an independent tribunal. And recently, as president, I made a finding in relation to a complaint in relation to 4 Aboriginal men with intellectual and cognitive disabilities who've been held for many years in a maximum security prison in the Northern Territory. Each complainant had been found unfit to stand trial or found not guilty by reason of insanity. And in respect of 2 of these men, they would have received a maximum sentence of 12 months had they been convicted. Instead, they were held for 4.5 years and 6 years respectively. The Commission and I as President found that the failure was a violation of the right not to be detained under the International Covenant on Civil and Political Rights, a provision, of course, that's in the spirit of the Magna Carta. Sadly, these provisions, and we're finding, I'd say, scores across Australia, particularly in Western Australia, Queensland and the Northern Territory, of these kinds of detentions. Very often, people for years, where had they been charged and successfully convicted of the offence, they would have had less than a year's prison sentence. But the tragedy also, of course, is that such detention disproportionately affects our Aboriginal and Torres Strait Islanders, a problem that is seriously exacerbated by the Northern Territory's paperless arrest powers introduced late last year, which permit detention without bringing the accused person before a court or magistrate of any kind for 4 hours. These detentions have increased the rate of detention of Aboriginal Australians, and deaths in custody continue as recently as a few weeks ago, 24 years after the Royal Commission report into deaths in custody in 1991. Well, of course, I could not be speaking about this without raising a matter that's been great concern to the Australian Human Rights Commission, and that is the power of the executive administratively to detain asylum seekers and refugees under the Migration Act, under the legislation, which of course gives the power to do so. We've also known, of course, that the majority view of the High Court of Australia in Al-Kateb confirmed that the mandatory and indefinite detention of refugees and asylum seekers is constitutionally valid. Most egregiously, those with ASIO adverse security assessments are also detained indefinitely, some of them children, and for years without meaningful legal access or access to the courts. At the moment, 2,026 people, including 138 children, remain in closed detention in Australia. 943 males remain on Manus Island, 100 on Christmas Island, and 448 refugees on Nauru, including 81 children. Most have been held for well over a year in conditions that have been criticised by the United Nations as breaching the Torture Convention. I think Doc Everett would have been horrified that at any stage in the future Australia should be accused of breaching such a serious convention and such serious rights. But there have been some recent cases that shine a legal light on the unconstrained right of parliaments to give the executive the power to detain. The High Court, for example, has said that Parliament cannot confer delegated legislative power on the minister to exercise an open-ended discretion with respect to aliens. And while this has received almost no attention in the media, the High Court has unanimously confirmed a writ of mandamus issued by the Chief Justice against the Minister for Immigration to require him to at least make a decision to grant a visa or to deport, one or the other, within a reasonable period of time. But I'd suggest to you that as punitive detention is for the courts alone, the prolonged and indefinite detention by the executive, whether those who are mentally ill, unfit to plead, or asylum seekers and refugees, has become punitive and therefore violates the principle of the separation of powers. Well, in conclusion, one of the many lessons that I've learned over my 3 years as president of the Australian Human Rights Commission is that, in fact, despite all I've said about the law, about our exceptionalism, our unique almost approach to detention centre policies, no other country in the world detains mandatorily and indefinitely, that one of the most effective safeguards for human rights in Australia is the cultural expectation that our freedoms will be protected. Most Australians will be highly unlikely to be able to describe the doctrine of the separation of powers, but they're very quick to assert their liberties under the rubric of a fair go, a phrase that is as close to a Bill of Rights in this country as I think we're ever going to get. But it's this cultural expectation of the Australian people that has been so hugely impressive to me over the last few months in particular. It's that expectation that keeps our freedoms alive today, and it was illustrated by the overwhelming community response to the need to preserve the Section 18C in the Race Discrimination Act that prohibits offending, insulting, intimidating and humiliating in the public arena people on the grounds of their race or nationality or ethnic origin. And we see the need for that value standard in Australian life more seriously today, perhaps, than we ever have done in the past. But what is critical is that the Australian public knows how important those provisions are, and they're prepared to stand up for the Race Discrimination Act, the 40th anniversary of which, of course, we celebrate this year. The scores of laws that I've been very briefly describing that do infringe our rights have confirmed my view that Australia does need a legislated Charter of Rights. I know this is not a view that all Australians share, but I believe that it's based on the extraordinary view that were we to pass a Charter of Rights, that would give our judges more power to interpret those rights to protect individual liberties. I do wonder where they think that our common law rights and fundamental freedoms came from. They came from the judges who built upon this remarkable doctrine of the Magna Carta itself. So why we have this fear of our judges, who I think are actually conservative, cautious, careful and very good lawyers, why we're so cautious of them, I really don't know. But I do think that it's time that we reopen the national debate about whether and what difference it would make if we had a Bill of Rights. Would we be giving the courts the power to challenge the executive and Parliament when they pass laws which fail to meet these core standards? At the moment, our courts do not have the tools or the equipment to do that, and I think it's time we had a national debate to reconsider the matter. But of course, ultimately, it's a national priority to educate young Australians so that they better understand and value the constitutional protections for democracy and the rule of law. I understand that in a survey done a couple of years ago, when Australians were asked if we had a constitution, something like 60% said we don't have a constitution. But when asked if we had a Bill of Rights, about 80% said yes, we do. And illustrating that is a case that I think occurred in New South Wales a few months ago. A man, as sadly so many are now, being charged with the murder of his wife, on being arrested by the police, said he wanted to take the Fifth Amendment. We really understand much more about our rights from American television programs than we do from our own education system. And I think at minimum, this is where we need to start, so that we can, our young people can understand the Constitution, understand its limitations, but its, of course, very great guarantees and benefits, to respect it, and to respect, of course, the independence of our judiciary. So, finally, can I say that despite challenging the power of the executive, as an English migrant and a dual citizen, I do hope that I can keep my Australian passport, escape statelessness, and retire to smell the roses. Thank you all very much. Thank you.